Hi, Wes Scott from Lifeback Law Firm. Today we're going to talk about can I keep my recreational vehicles in bankruptcy by Dr. Tim Tonga. It's a good question. A lot of people have toys, right? And again, this question really centers around two questions, really. It breaks down to two questions. Number one, can I keep the equity I might have in my toy? For example, say you got a 1983 Honda three-wheeler. It's still running because it's a Honda. And it's worth $1,500. You don't owe any debts against it. The question is, can you keep that three-wheeler? And the answer is, it depends on which set of exemptions you are using and if you have available wild card exemption left over or a vehicle exemption because it's a vehicle. So that's one question. And a lot of people are able to keep the equity they have in these toys. And then the second question becomes, can you keep the vehicle as between you and the lender that may have a loan against it? So for example, you buy a four-wheeler, you owe $8,000 on it. It's worth $8,000, so there's no equity to protect or lose, right? So then we're solely talking about, will you lose the four-wheeler as between you and the lender? And that answer is this. The lender's security interest survives the bankruptcy. You don't make payments on it. They can take their collateral back. You're not liable on the loan anymore, but if you don't make payments on the loan, they have the right to take their collateral back. So often, as long as you're current on the payments, you don't lose the vehicle as between you and the lender when the time is right. When you are ready to get your life back with Minnesota's most kind and helpful bankruptcy law firm, reach out to Lifeback Law Firm. You're going to be so thankful you did.